report from Dr. Holden, correct?
I did.
And what steps did you take that you can tell us when you compared your report to Dr. Holden's report?
Am I able to reference any document? I mean, I can tell you.
Would it assist your answer by looking at a document, and I can provide it to Brother Counsel? Would you be able to answer your question if you're able to look at the papers contained in your folder there?
Yes, ma'am.
Thank you. You may approach the witness. Please show the prosecutor.
And he actually has a copy.
Thank you.
So what is it that you did with your report compared to Dr. Holden's report?
So when the concerns were raised about the similarity of their reports, and I've done this before, I tasked my assistant with doing 2 independent searches. There's a program called CopyLeaks and another one called editpad.org. What these programs do, they take one report, line it up with the other, and then they look for similarities and consistencies or differences. So that's what I had my assistant do, just because I anticipated that this was going to be an issue. So I have the results that my assistant ran.
Okay, so I want to focus on identical match. What percentage of these 2 reports is an identical match?
Judge, I'm going to object to this until that other report is admitted. I don't think this document in any way, I want Dr. Holden's report admitted before there's a comparison, please.
Thank you. So I need to understand your legal objection. What's your legal objection to this line of question?
That there's not a foundation for this testimony without Dr. Holden's report. This is now a comparison between his report and Dr. Holden's report. Her report is not in evidence.
Thank you. I agree with that, but I haven't seen Dr. Holden's report either, so that's not substantive evidence that's before this court. So the objection's overruled. You may continue with your line of questioning, but noting that the court has no idea what's inside Dr. Holden's report.
Understood. Thank you very much. I'm just going to ask one question. The percentage of the identical match between the 2 reports is what?
1.3%.
Thank you. You were also asked and shown your report on a case of People versus Jamar Johnson, correct?
That is correct.
It's my understanding from that case, Mr. Johnson had already done a significant period of time in prison, correct?
That is correct.
And so you were able to review prison records for a number of years for Mr. Johnson, correct?
That is correct.
So would you agree with me that it would be much easier to talk about the rehabilitation prospects or the actual rehabilitation when you have years of prison records showing that he either changed his behavior or listing all of the good things that he's done?
That is correct.
So your report here on Mr. Crumbley is different, and different than probably almost all of the reports you completed, because Mr. Crumbley hasn't been to prison yet, correct?
That is correct.
So you don't have a number of years of behavior, tickets, programs completed to look at, correct?
That is correct.
You were asked about the 4th Miller factor and the fact that you didn't address it. But you did actually do a competency test where you measure if he's able to assist his attorney in his own defense, correct?
That is correct.
So you may not have actually listed that 4th factor, but you definitely addressed it, correct?
I did.
May I have one moment?
Yes.
I have no further questions.
Judges, very briefly.
There, counsel approach. Absolutely. Thank you. The court will note that the time is approximately 3:44 p.m. I note that the people intend on calling a rebuttal witness. Defense, do you have any further witnesses at this time?
We don't have any further witnesses, Your Honor, but I'm asking that you note the last 4 exhibits in my binder that have been admitted. Exhibit T, there are letters of support from 2 family members of Ethan Crumbley. Exhibit U, it's a report of the legal guardian ad litem, Ms. McKelvey. V, the Violence Project report, which is a report that was created at the people's request in the parents' case. And W, a stipulation on the GED examination that will show that Ethan Crumbley paid for and completed all necessary testing to be able to take the GED, but unfortunately the jail could not accommodate that. Other than that, Your Honor, we rest.
Thank you. The court will so reflect counsel's statements this afternoon. I note again that the people intend on calling a rebuttal witness. The time, we're late in the day, and so there's no way possible that we're going to be able to get through the people's rebuttal witness before 4:30 p.m. I will also note that you all cannot return tomorrow. As you all are aware, we have to put a lot of things in place in order to have these hearings for 3 days, and so we need to make sure for building safety issues, we need to make sure that we also confer with the Oakland County Sheriff's Department. And so to make all of that happen, we need to adjourn this to another date, as well as the court is unavailable for some dates. And so the return date that I discussed with counsel is August 18th, 2023 at 9 a.m. Counsel's already confirmed that that date works for them. I will also note that we need to address the defendant's placement at the Oakland County Jail, as we must review that every 30 days. People, any statements that relate to the defendant's placement at the Oakland County Jail?
Judge, we don't believe there's any changes. We believe the placement's appropriate.
Thank you, defense.
We have no arguments.
Thank you. Based upon the court's previous rulings, the court does continue to believe that it is in the best interest of justice to continue the defendant's placement at the Oakland County Jail. We will return here August 18th, 2023 at 9 a.m. to continue this hearing. At that time, the court will also give you another review hearing date as well as a decision date. As I discussed off the record, there are some things that I need to address with the Michigan Department of Corrections before I set a sentencing date in this case. Anything else we need to address for the record before we hear for today?
No, Your Honor.
No, Your Honor. Thank you.
Thank you. Deputy, you will take the defendant. And please be seated in the courtroom while he's exiting.